Welcome to a long-awaited collection of videos on the 2021 Louisiana Legislative Session. This is the state of things on workers' rights and climate activism. First are some of our most important bills of LaReform on workers' rights. Two of these bills we highlighted from the very beginning on our blog, but they did not even get heard on the Senate Committee of Labor and Industrial Relations. SB 7 raises the minimum wage gradually over the next couple of years in the state to $11 an hour in 2022, $13 an hour in 2024, and $15 an hour in 2026. SB 49 raises the minimum wage to $15 an hour in 2022 and sets a law that will raise the minimum wage annually based on the increase in the Consumer Price Index for all urban consumers. Another important bill that we followed from the beginning of the legislative session, we were present at the hearing. HB 67 decriminalizes prostitution in the state of Louisiana but does not add any regulation on sex work. Learn more about this in my Summing It Up video. Many people across the state came to testify in favor of the bill, including me.
My name is Andrew Lewis. I helped establish the Greater New Orleans Human Trafficking Task Force in 2015, and I'm a strong supporter of HB 67. I was invited to observe a joint sting operation. When a sex worker arrived to the hotel room, they would be arrested and forced into another cold room, often with very little clothing, and interviewed. The same agent that handcuffed them would then ask them if they had been trafficked. And no matter their response, they were arrested and booked. This method of data collection and investigation is morally wrong, violent, and harmful.
For sex workers and many trying to survive, that labor has been heavily policed.
Other multiple international studies have found that criminalization laws and policing elevate sex workers' risk for negative health outcomes like PTSD, STIs, and violence at the hands of clients and police alike.
Before we demonize these women and we talk about morality, if we don't decriminalize, then we need to talk about the patrons of sex workers, because they are now criminals too.
Yet this bill did not pass the House Committee on Criminal Justice. There were also several attempts at legalizing and decriminalizing recreational use of marijuana. HB 699 legalizes the recreational and selling of marijuana in Louisiana by providing multiple provisions on regulations. It was the most major bill on marijuana in this session, but it was pushed back on the schedule and never voted on in the House chamber. HB 440 went hand in hand with HB 699, and it was another one that was pushed back and never voted on in the House chamber. It would have created an annual fee to be licensed to sell marijuana in Louisiana at $2,500 once recreational use is legalized, something we think is way too high a price. HB 568 levies a tax on cannabis if it were to be legal in Louisiana. This one was never heard in the House Committee on Ways and Means. HB 567 removes unnecessary taxation on dealers and provisions for marijuana. This one passed unanimously in the House Committee on Ways and Means, but it was also pushed back and never voted on in the House chamber. Next, we have a couple of bills that are helpful for workers' rights. HB 610 increases the amount of benefits someone can gain from unemployment. In the House Committee on Labor and Industrial Relations, the bill passed unanimously. During the hearing, state workers explained how the bill does not change current programs and how it encourages people to get back to work.
Well, my name is Renita Ward-Williams. I'm Deputy Secretary for the Louisiana Workforce Commission. Well, yeah, there is concern about a disincentive to work, but the majority of that concern is related to the federal benefits. So the $300 plus up that's added on to everybody's weekly benefit amount. So absent some federal extension beyond September 6th, that would be it. They would have the $275 or whatever amount we're raising this to, depending on the procedure, and it would be those state benefits with no additional federal benefit available. We are encouraging individuals to return to work.
Your statement was really where you're leading into my question. They can't get people to come back to work. And I would like to know what the department is actively doing to make sure that these folks who can work are actually going back to work, because we have plenty jobs available.
You cannot refuse work and continue to receive Louisiana unemployment insurance benefits. Under the CARES Act, there are COVID reasons, but that would mean that you are not on a state unemployment insurance claim. In Work Search, you have to let us know which employers you have applied for, where you are in the process with them. You have to give us the name of those employers, the address, and when you went or when you applied for that employment. But again, this particular bill has nothing to do with those that are on CARES right now.
With amendments, do I hear any objections? Hearing none, the bill is reported with amendments favorable.
Yet it did not pass in the House chamber. HB 439 creates an option for employees to litigate a sexual harassment case no matter if they had to sign an arbitration clause in their employment. During the committee hearing for this bill, Chancellor Pierre at Southern University Law Center explained the difference between arbitration and litigation, and why it is so important that a victim has a choice for litigation.
When we have litigation, we have the ability for a citizen to exercise all of their constitutional rights, the right of appeal and so forth and so on. Arbitration restricts that. Certainly there would be arguments that arbitration is perhaps less expensive than litigation. But when you start talking about issues related to sexual harassment, you need to ask yourself, is it a situation where arbitration should be the only remedy available to a potential victim of sexual harassment?
Now, Rep. Newell, all you're trying to do is give persons who have been sexually harassed an opportunity to have their day in court. And that's due process and constitutional rights.
Yes.
Newell, okay.
You're not taking anything away. You're just adding some flexibility. Am I correct?
Yes, sir. Just adding another option.
At the appropriate time, Madam Chair, I would like to move forward with this bill.
Thank you.
Representative Freeman asked about current statistics and more.
Were these contractual employees? Were they just regular employees like you and I would hire at our law firm, or I don't know. I've never seen it. That's why I'm trying to get my hands around how this plays out in the real world.
Let me answer that, if you will. Many times they would say arbitration is a favored tool when it comes to dealing with employee disputes.
Right now, most contracts only allow arbitration, period. Nothing else. This would allow for litigation as well.
I think we may just see it a little bit differently, but thank you for answering my questions.
And ultimately voted against the bill. So this bill did not pass. That same day, SB 61 was heard in that same committee. SB 61 is the Hair Crown Act to prevent employment discrimination against people with protective hairstyles and natural hairstyles, including braids, locks, and twists. During the committee hearing, Senator Troy Carter had to put black women on display to explain protective hairstyles and natural black hair to white women legislators on the committee.
I have a problem. What about people who want to come to work with a beard?
This bill doesn't speak to beards. No.
It's God-given.
No, ma'am. With all due respect, you're suggesting styles, and I've just got to push.
Well, it does say that, natural hairstyle.
Well, natural hairstyle, but it also clarifies that it's natural.
It's confusing.
But you know what? But Madam Chair, I really do appreciate the opportunity because it's as much education for us all. Suppose an employer said, you can't have your hair straight. Mm-hmm. You have to have that perm that you did 10 years ago. How would you feel about that? You would have a bill to say, wait a minute.
I wouldn't need a bill. I have the Constitution.
I'm going to agree to just stop there because I know that's not what you meant, but boy, it was really offensive. And because I know your heart.
Absolutely.
And you're my friend.
You are my friend.
So I want to say for the record,
Forgive me
you didn't
if I
mean
did.
what you just said.
If we could stop, for the purposes of this section, the term race shall include traits historically associated with race, including but not limited to hair texture. Stop.
So you're suggesting we take out protective hairstyles?
Protective hairstyles.
Could I offer Exhibit 1?
That's not God-given. That's not God.
Sure it is. It's just a design.
It's beautiful, and I love it. My kids want to do their hair like yours.
That's natural, right?
And I can show you a protective.
That's a protected style.
This is the protected style. And I can show you more protection for my hair.
Listen.
That's a twist of a protective of her natural hair. So that is why that is needed.
That's why that part's important.
Representative Horton voted in favor of the bill, but Representative Hodges did not. This bill passed through the Senate unanimously with 11 co-authors and ultimately passed this committee hearing. But it was never voted on in the House chambers, so it never ended up on the governor's desk. There were also a couple bills on human trafficking, and human trafficking is the act of not giving proper rights to workers. SB 170 creates the Office of Human Trafficking Prevention within the Office of the Governor to provide support services for human trafficking victims. This bill passed with little objection and was ultimately signed by the governor. HB 227 allows subpoenas for evidence of human trafficking from online sources that are suspected to be sex trafficking minors. This one was also signed into law by the governor. There were two more bills that were passed through the legislature for workers' rights. SB 215 requires an employer to provide more breaks, a breastfeeding area, and more for pregnant employees. This was a great step in Louisiana for assisting people in maternity. This one was signed into law by the governor. HB 707 prevents employers from considering an arrest record or charge from a background check that did not result in a conviction. This one was also signed into law by the governor. Check back later for more on the state of things. Like, comment, subscribe.